Now that we've covered all the essential topics we need to know about independent contractors, there are three top tips that we need to discuss before hiring independent contractors. Tip number one is to use independent contractor agreement before the engagement begins so that your independent contractor is not misclassified as an employee. Misclassification can create serious legal problems, including audits of the entire workforce by federal and state tax authorities and the imposition of penalties. This is an area of increasing concerns because both federal and state governments are increasing efforts to investigate employee misclassification issues to recoup lost revenue through penalties. A worker status can affect the rights of the employer to any copyrightable works or patentable inventions created by the worker. For example, employer is generally deemed to be the author of and therefore the owner of the copyright for any works created by an employee acting within the scope of employment. Similarly, the employer is the owner of any invention created by an employee hired to invent. It's important to know that a work created by an independent contractor is not owned by the company unless the company secures either a written contract stating that the work is a work made for hire or a written assignment of the copyright. Similarly, independent contractors own their inventions and any patents absent a written assignment of inventions. So make sure to have your worker sign an independent contractor agreement before he or she starts working for you. Tip number two. Make sure you treat your independent contractors as a contractor and not as an employee. This means that you shouldn't control your contractor or micromanage them. This is true even if you have an independent contractor agreement in place. We've already talked about the various tests of employees versus independent contractors. It's important to keep all these factors in mind in how you're treating your workers. Sometimes how you treat them determines whether they're considered independent contractors or employees. Of course, you should always speak with the business lawyer if you have any doubts or questions about the applications of these issues. And tip number three, do not leave anything to chance. The terms of your independent contractor should be in writing and in great detail to prove the independency from the company. You should make every attempt to determine the proper status of the worker before the worker relationship begins. The written independent contractor agreement can be helpful in case of disputes in proving that there was a contract and just what was agreed. Without a written agreement, if the dispute has to go to court, the court will only have each other's word to assist in working out what happened. So always make sure you have your independent contractor agreement in writing and have your worker sign and date the contract before you begin any work with the worker.